agency. As a real estate agent, the term fiduciary relationship comes up on a regular basis. A fiduciary relationship is a legal relationship that creates a position of trust and confidence. The acronym ACOLD will help you remember your duties in a fiduciary relationship. As an agent, you must be accountable, use care and skill, obey legal instructions, be loyal to your client, and disclose all pertinent information. Loyalty means the principal's interest must come before anyone else. It means keeping confidential information confidential. That is, information that would affect the bargaining position of the client. An example of this would be to not disclose that the client is going through a divorce. The law of agency defines the rights, duties, and responsibilities of all legal parties. An agency relationship is a relationship in which an agent is authorized to perform certain acts on behalf of a principal. If the agency relationship changes at any time during the transaction, the change must be disclosed in writing, and the party must consent to the change. An agent is a party who acts for and in place of a principal. There are 3 types of agent a person can be: universal, general, and special. A universal agent is one who has been given full power to act on behalf of a person or business. A general agent is authorized by the principal to perform any and all acts associated with the ongoing operation of the job or business. A real estate licensee acting in the capacity of a property manager is a general agent to the owner. A special agent is one who has limited authority granted to him or her through a principal. The relationship with the principal is not expected to be continuous. The listing contract creates a special agency relationship with the seller. The authority is limited to the duties given in the listing contract, and the relationship ends when the terms have been fulfilled. An attorney, in fact, is a person authorized to perform certain acts for another person under power of attorney. A principal is any person involved in a contract, such as a seller, buyer, principal broker, or an owner who has hired an agent as a property manager. A client is a party who has signed an agreement with an agent, and this agreement creates a fiduciary relationship. A customer uses the services of a real estate licensee but has not signed an agreement with an agent. Even though there is not a fiduciary relationship with the customer, the lessee must act honestly and fairly with the customer. When you list a property, you are representing the seller. As a licensed real estate professional, it is your duty to make sure the buyer understands that you represent the seller. A seller who enters into a listing contract with a brokerage firm is a client of the listing agent's company, not of the agent themselves. The brokerage firm and the listing agent are required to act on behalf of the seller's interest. When a real estate broker enters into a contract with the buyer becomes the client and the seller becomes the customer. A buyer's broker may be paid by the seller, the buyer, or both. Because of the contractual relationship, the agent is still a buyer's agent if the seller pays the commission. Let's discuss dual agency. Usually, the agent who obtained the listing becomes the designated agent of the seller, and no other licensee within the company would represent the seller. If another agent from the same brokerage secures a buyer, that agent would be a buyer's agent, and the brokerage firm would be a dual agent. A dual agency is legal as long as everything is disclosed and everyone agrees. A dual agency is created when the licensee represents the buyer and seller as clients in the same transaction, or if the brokerage firm represents both. In a dual agency, both the buyer and seller are clients. A transaction broker provides the buyer and seller with the necessary paperwork to transfer the property, and both parties are customers of the broker. The seller and buyer negotiate the sale without the broker. The transaction broker must act honestly and fairly, disclose all property defects, but must not disclose confidential information to either party. A transaction broker is also called a non-agent, a facilitator, or an intermediary. An undisclosed agency is created when an agent deals with a third party, and the third party has no knowledge that the agent is acting on a principal's behalf. When the third party learns of the undisclosed agency, he or she may seek remedy from the agent and/or the principal. This concludes the section on agency.